Welcome back, everybody.
Ready for another deep dive?
Absolutely. Always ready to explore.
Okay, great. Today, we're going deep into strategic legal pleading.
Ooh, sounds intriguing.
You've got some really cool legal guides and even some juicy case summaries to work with.
Nice. So
Yeah.
we're not just talking theory here. We're looking at how this stuff plays out in the real world.
Exactly. Our mission today is to understand how lawyers can actually use these pleadings.
The first moves in a legal battle.
Yeah, to kind of shape the whole case.
It's like they're setting the rules of the game before it even starts, right?
Right. And we're going to see how these choices they make at the very beginning.
Seemingly small things.
Yeah, they can have like huge ripple effects. We'll even be looking at some kind of surprising cases.
Cases where these tactics, well, maybe they backfired or they totally changed the game.
Definitely. Okay, so let's jump in. One of the big takeaways from strategic pleading and judgment effects is that lawyers have to be super strategic about what they even include in their pleadings.
Right, like choosing which issues to even bring up.
Uh-huh.
Who to name as parties in the case.
And what remedies they're even asking for. Like, all of that basically predetermines the whole trajectory of the case.
Totally.
So it's like choosing your battlefield.
Exactly. You're setting the stage.
And speaking of battlefields, Section 8 of Tactics and Strategy of Pleading talks about choice of forum. Basically, how lawyers can maneuver to get a case heard in a specific court.
Right, because different courts can have different rules, different judges, different juries. All of that can impact the outcome of a case.
So it's not just about what you argue, it's about where you argue it.
Precisely. And Section 9 dives into this idea of subject matter jurisdiction.
Which basically means making sure you're in the right court system for your case.
Exactly.
Yeah.
Like, let's say you've got a case that could be heard in either state or federal court.
Okay.
By adjusting the amount of money they're demanding, lawyers can sometimes influence which court will actually hear the case.
So there's this strategic balance, right?
Yeah.
Like, you want to get into the court that's best for your case, but you can't just inflate the claim to do it.
Right, because if the court thinks you're being dishonest or exaggerating just to manipulate jurisdiction, they can throw the book at you. Section 9 definitely cautions against that.
Makes sense.
Yeah.
But what if the claim is legit, but it's just too small to get into federal court, for example?
Well, there's this thing called joinder that Section 11 talks about.
Joinder.
It basically means combining claims or parties.
Okay.
So imagine you have a bunch of small claims that wouldn't individually meet the requirements for federal court. But if they're all related, you might be able to combine them into one big lawsuit that does meet the requirements.
So it's like bundling them together to reach that higher threshold.
Exactly.
That's really interesting. So we've talked about choosing the right court.
Yeah.
But what about when? Like, we've all heard of the statute of limitations,
I don't know,
right?
that ticking clock.
That can totally make or break a case. Can lawyers play around with that too?
You'd be surprised. Our guide goes deep into this in Section 70 onwards.
Okay.
Sometimes lawyers get creative and classify a case under a legal theory that has a longer statute of limitations.
So they're basically reframing the whole issue.
Kind of. It's all about finding the approach that gives their client the most time.
Can you give me an example?
Sure, imagine someone's injured. Right.
Mhm.
Because of someone else's actions. The lawyer might frame the case as negligence, which often has a longer statute of limitations, you see. Longer than if they filed it as, say, assault.
It's not always straightforward.
Not at all. And Section 72 even talks about arguing for a later accrual date.
Cruel date? What's that?
It's when the clock starts ticking on that statute of limitations.
Gotcha.
And it's not always as simple as the date of the incident. Lawyers can argue, for example, that the clock didn't actually start until the injured party discovered the harm.
Which could be much later.
Exactly. Or they might argue that the defendant was hiding the harm, which should also delay the start.
Wow, so there's a lot of wiggle room there.
There can be. Section 73 even mentions alleging recent discovery or the defendant's estoppel.
So it's not a fixed timeline.
Nope. Lawyers can definitely try to shift the starting point. It adds a whole other layer of strategy to the whole thing.
And all of this is happening before we even get to the actual arguments of the case.
Exactly. These initial pleadings set the entire stage, so lawyers who are skilled in this area, they can really impact how the whole case plays out.
It makes you realize that these early stages are like super crucial.
Absolutely. They lay the groundwork for everything that follows.
But I have a question. What about the defendant? I mean, it feels like the plaintiff gets to make all these choices.
Sure, the plaintiff might have more choices at the beginning, but the defendant has a big advantage.
Oh, what's that?
The burden of proof. It always falls on the plaintiff.
Ah, So no matter how well the plaintiff's lawyer sets the stage.
They still have to prove their case.
That makes sense.
Yeah.
But this deep dive is all about giving our listener, real practical knowledge. So let's get tactical. What are some ways lawyers use these pleadings to, like, dodge defenses? Or maybe even maximize what their client could recover?
Well, Section 76 highlights how pleadings can be used to avoid certain defenses.
Like what?
Like lack of respondent superior.
Respondent superior.
It's a legal doctrine that can make an employer liable for their employees' actions.
Okay, so like if I'm injured by a delivery driver, I could sue the company they work for.
Exactly. So by strategically naming the company in those pleadings, the plaintiff's lawyer might be able to get a bigger payout.
That's a good tactic. And what about defenses like contributory negligence? Section 77 mentions that one.
Right. So let's say you're in a car accident and you were partly at fault.
Okay.
A skilled lawyer might use the pleadings to really emphasize the other driver's recklessness or maybe highlight other things that contributed to the accident. That shifts the focus away from their client's fault, you see.
So it's about telling the most persuasive story, even if it's based on the same set of facts.
You got it?
And hey, remember joinder. We talked about that earlier.
Yeah.
Does that play a role in maximizing recovery too?
It can. Sections 88 through 90 explore how joinder can potentially increase how much a plaintiff might get.
Oh, I see. Like in those car accident examples they use, let's say it's a multi-car pileup.
Mm-hmm.
A lawyer could sue all the drivers, right?
Yep, to try and get more money. But there's a catch, which sections 89 and 90 point out. Joining all those parties can make the case way more complicated and actually harder to win.
So it's a gamble.
It is. A strategic decision, weighing the risks and benefits.
It feels like every choice in this process is super strategic.
It really is. There's no one-size-fits-all approach. Each case is unique.
This is blowing my mind. Seriously, all this strategizing is happening before we even get to the main arguments.
Right. It's all about setting the stage.
You know what would really help me understand this better? Real-life examples. Like cases where we see these tactics actually playing out.
Oh, yeah, for sure. Because these theories can seem abstract, you know?
Yeah, like what does this actually look like in court?
Exactly. So seeing how they impact real people, that makes everything much clearer.
And that's exactly what we're going to do next. We've got some really interesting case summaries with some pretty wild outcomes that'll really bring this all to life. So stay tuned. Okay, so let's dive into these cases. This first one, Deliberty v. Stage Call Corp., is a perfect example of how important precision is in legal pleadings.
Oh, yeah, this one is a classic.
The lawyer made a mistake naming the plaintiff, and it ended up costing them the whole case.
Yeah, their motion to amend was denied, all because of a little mistake.
It really shows you how much these details matter. Every word counts.
Absolutely. And McClellan v. Lone Star Gas Co. kind of reinforces that idea.
Right, but in a different way.
This case basically says that even if a pleading doesn't strictly follow the rules for formatting.
Like, it doesn't look exactly right.
Yeah, the court still has to accept it. As long as it, meets all the basic requirements for a pleading.
So it's more about the substance than the style.
Exactly. The court isn't trying to, punish little technicalities.
Well, that's good to know. Especially because even the best lawyers can make mistakes, right?
Oh, yeah. I mean, take King v. Cook, for example.
What had him there?
Simple word processing error almost cost them the entire case.
No way.
Yeah, but luckily the court let him fix it.
Well, that's a relief.
It shows that the system does have some flexibility, right?
Definitely.
Yeah.
But it's still a good reminder to always double-check your work.
Absolutely. Attention to detail is crucial.
And then there's Dotson v. Bravo. This one's kind of wild.
Oh, yeah. This one's a doozy.
The plaintiff tried to use a fake name.
And the court was not having it. They dismissed the whole case.
Wow. Talk about a backfire.
It shows that there are limits to how far you can push things, right?
Definitely. You can't just game the system.
Right. Honesty and respect for the process are key.
These cases really highlight the human side of this whole thing.
Mm-hmm.
But let's zoom out a bit. I'm curious, how does this play out in, say, contract cases, where it's all about agreements and disputes over terms?
Ah, yeah, contract cases. Section 29 of our Tactics and Strategy of Pleading Guide gets into that.
Okay.
It actually says that lawyers can use the specific language in a contract to determine the best place to file the lawsuit.
Oh, interesting.
So, A location clause in a contract could actually become a strategic tool.
It's all about leverage, right?
Exactly. Finding those little details that you can use to your advantage. And Section 30 goes even deeper into that, talking about venue in contract actions.
So like where the case will actually be heard.
Exactly. And sometimes a lawyer has to make a tough choice. Do they enforce the contract as it's written?
Okay.
Or do they go for a claim based on an implied legal obligation? The answer can depend on which path leads to the better venue.
So it's like picking your battleground again.
Exactly. But what if a contract has an arbitration clause, where it says any disputes have to be settled through arbitration?
Right, not a traditional lawsuit.
Can a lawyer get around that using pleadings? Well, sections 50 through 53 actually outline some strategies for challenging arbitration clauses.
Oh, so it's not a done deal.
Nope. A lawyer could argue that the dispute falls outside of the agreement.
Okay.
Or that the other side waived their right to arbitration. There are options.
So even with a contract, there's still room for strategic maneuvering.
Always. It's all about how you present the case.
This is so interesting. What about tort cases? Those tend to be a bit more...
dramatic.
Yeah. With accidents and injuries and all that.
Right. Well, torts cover a huge range of situations, from car accidents to defamation to, medical malpractice. Basically, any claim of harm caused by someone else's actions.
Okay, so in those cases, how does strategic pleading come into play?
Let's take a product liability case, for example. Section 32 of our guide points out that if you're injured by a defective product, you actually have a few options for how to plead the case.
Like what?
You could argue negligence, meaning the manufacturer messed up somehow.
Okay.
Or you could go with a breach of warranty claim, meaning the product didn't live up to its promises.
So even with the same injury, you have different ways to approach it.
You do. And each approach comes with its own set of rules and potential defects.
So the way you frame it in the pleadings really matters.
Big time. It affects what you have to prove and what evidence you'll need.
I'm starting to see the bigger picture here. It's not just about stating facts. It's about presenting them in a way that supports your legal argument.
Exactly.
Do lawyers ever plead multiple theories, just in case one doesn't work out?
Oh, all the time. It's like having a backup plan, If one argument fails, they've got others ready to go.
That's smart. But what about cases where it's hard to prove negligence? Like, you just can't figure out how a product became defective.
Tough situations for sure. But Section 78 suggests some alternatives.
Okay.
They might go with a breach of warranty claim, like we talked about,
Uh-huh.
or they could claim the seller misrepresented the product, saying it was safe when it wasn't. And sometimes they even go for a strict liability claim.
Strict liability, what's that?
Basically, it means the defendant is responsible for any harm caused by their product, even if they weren't directly negligent.
Whoa.
Yeah, it often applies to products that are inherently dangerous.
So like fireworks.
Exactly. Even if you can't prove the manufacturer was careless, you might still be able to sue them under strict liability.
That sounds like a really strong argument for the plaintiff.
It can be, but there are still defenses available in strict liability cases. It's not a guaranteed win.
This is so fascinating. I can't believe how much strategy goes into these pleadings. They really are the foundation of the whole case.
Absolutely. And it shows how important it is to have a good lawyer, someone who understands all these nuances.
I'm definitely starting to see that. But before we move on, I want to bring it back to the human element. We've talked about judges and juries. But what about the lawyers themselves? How do their personalities and choices affect things?
It's an interesting question. Because lawyers are people too, right?
Right.
They all have their own experiences, their own perspectives, their own styles, and all of that can definitely influence how a case goes.
So it's like they're all playing the same game, but with different strategies.
Exactly. Some lawyers are super aggressive, some are more collaborative, some are amazing with the technical stuff, and some are really good at connecting with juries.
So it's not just about knowing the law, it's about how you use it.
Exactly. And how you present yourself in court, how you interact with the other side, how you argue your points, even how you dress. All of that can have an impact.
It almost sounds like a performance.
It kind of is. You have to capture people's attention. You have to be persuasive.
It's not just what you say, it's how you say it.
Totally. Lawyers who can communicate effectively, they definitely have an advantage.
Wow, this has been so eye-opening. I feel like I'm seeing the whole legal system in a new light.
It's definitely more complex than it seems on the surface.
For sure. But before we wrap things up, I want to go back to something we touched on earlier, the ethical considerations.
Oh, yeah. That's super important because strategy is key, but lawyers can't just do whatever they want.
Right.
They have to operate ethically. And those ethics are woven throughout this whole pleading process. Like, lawyers can't lie in their pleadings. They can't misrepresent facts.
That seems pretty basic.
It is, but there are definitely some gray areas. Sometimes it's tough to balance advocating for your client with staying on the right side of the ethical line.
So how do lawyers deal with that?
They rely on their training, their own judgment, and often advice from more experienced colleagues, and they have to know the specific rules for their jurisdiction.
And those rules are serious business, right?
Oh, yeah, if you break them, there can be serious consequences.
So ethical considerations are just as important as strategic ones.
Absolutely. You can't have one without the other. That's a key takeaway here.
That's a great point. Okay, well, we've covered so much in this deep dive.
You really have.
From the very basics of legal pleading to all the strategies and ethical dilemmas. It's been amazing.
I'm glad you've enjoyed it.
I have, for sure. And I'm sure our listener has too.
I hope so.
But before we wrap up this episode, I want to hear your final thoughts. What's like the big takeaway here?
Well, we've gone deep into the strategic side of things, right? But it's important to remember that these pleadings have a bigger purpose. They're about seeking justice, upholding the law, and making sure everyone has a fair chance in court.
That's a really important point. It's easy to get caught up in all the tactics and technicalities, but ultimately it's about fairness.
Exactly. And that's something we all need to keep in mind, whether we're lawyers, clients, or just people interested in the legal world.
That's a perfect way to wrap up this deep dive. Thank you so much for sharing your expertise with us today.
It's been a pleasure.
And for our listener, until next time, keep diving deep. It really makes you think, all the stuff that goes on behind the scenes of a legal case. It's a lot more than just presenting evidence in a courtroom.
It really is. And the strategies involved, they're constantly changing, adapting. It's fascinating.
Definitely. Speaking of changes, I'm curious, what kind of new trends or challenges are you seeing in legal pleading these days? Is technology shaking things up?
Technology's having a huge impact, no doubt about it. Like electronic filing, that's becoming the norm now.
Yeah, I can see how that would make things more efficient.
Definitely streamlines things, Less paperwork, faster turnaround times. But of course, it comes with its own set of challenges.
Oh, for sure. Like what?
Well, cybersecurity is a big one. Making sure all those sensitive documents and case files stay secure.
Right. With everything being digital, that's a huge concern.
It is. We can't forget about data breaches and hacking and all that. And then there's AI.
AI, like artificial intelligence.
Yep. AI is starting to pop up everywhere in the legal field, including pleadings.
Wow, seriously.
Yeah, we're already seeing AI tools that help with research, document review, even drafting those initial pleadings.
That's kind of mind-blowing. But I have to ask, what about the ethical implications? Like, what about bias in algorithms? Or lawyers becoming too reliant on technology?
Those are all valid concerns. We can't just hand everything over to machines, right?
Right.
Technology is a tool, that's all. It can help lawyers do their jobs better, but it can't replace human judgment or critical thinking or ethical decision-making.
So at the end of the day, it's still a human-driven profession.
100%. Legal pleading, it's about people. Lawyers advocating for their clients, judges interpreting the law, juries making those tough decisions. Technology can assist, but it can't replace that human element.
That's a good point. This whole conversation has been so enlightening. I feel like I have a much deeper understanding of the legal system now.
Yeah.
It's so much more complex and nuanced than I ever realized.
I'm glad to hear that. That's the goal, right? To demystify things a bit.
Absolutely. Well, on that note, I think it's time to wrap up this deep dive. Any final thoughts you want to leave our listeners with?
Just this. We've talked a lot about strategy, tactics, all the ins and outs of legal pleading. But remember, at its core, the law is about seeking justice, making sure everyone has a fair chance. That's something we should all keep in mind.
Well said. That's a perfect note to end on. Thank you so much for joining us today and sharing your expertise.
It's been my pleasure.
And to all our listeners, thank you for tuning in. Until next time, keep exploring, keep asking questions, and keep diving deep into the fascinating world around us.
Thank you for joining us. Please like, subscribe, and share this video podcast. Also, go on over to Amazon and get a copy of my book. The link is in the description. Also, legalwritingusa.com.